Hello friends, and welcome back to the study series of Jurisprudence, Interpretation and General Laws. So in this video, I'm going to be starting with customs or customary law. Now in my previous video, I had given a lot of importance to statutes and legislation and judicial decisions and precedents, because not only do they constitute one of the most important topics in this chapter, it is also very crucial to understand these two topics much better to go into all the other chapters in this subject of jurisprudence. Now in this video, I'm going to be starting with customs and customary law and moving on to personal laws. So let's start with customary law. So what is customs or customary law? Custom is the most ancient of all the sources of law, and it's the most important one from the past. Now they are saying that customary law is diminishing with the growth of legislation and precedent. What do you mean by this? So what you need to understand is that customs are those kind of practices which have existed from ages past, from a really long time ago. So customs were what existed prior to something known as statutes and legislations or judicial precedents coming up. Laws are made by the legislature. The legislature gets its power from the constitution. And the constitution only came into force in the year 1950. So customs are those kind of practices which I can say are basically evolved through time. But first let's go through a classification of customs. So customs can be divided into two classes. The first one is customs with sanction and customs without sanction. So what do you mean by sanction? Sanction simply means punishment. So there are some customs which, if not followed properly, then you can be punished for it. Whereas there are some other customs which, if you practice it or if you don't practice it also, nobody will really care about it. Now take for example, customs with having sanction. The practice of sati. The practice of sati was a custom that existed in ancient India. Now, this practice was abolished by the coming in of some kind of a law known as the Sati Prevention Act. So this is known as a custom having sanction. So here a custom was banished by a law. Whereas there are some other custom. The custom of a married woman putting the red sindoor on her forehead. That is a custom. Whether people practice it or not, it won't really be punishable by law. Now these customs having sanction are divided into two parts, into legal and into conventional. So what are legal customs? Legal customs operate as the binding rule of law. Customs operate as the binding rule of law. What do you mean? What does it mean? What do you mean by that? They have been recognized and enforced by the courts, and therefore they have become part of the law of the land. So that means legal customs are those customs which have received some kind of legal attention or legal sanction. Okay. These legal customs are further divided into two parts, local customs and general customs. But before we go on to what legal customs were further divided into, let us first understand what the conventional custom is. Remember, we studied that customs are divided into legal and conventional over here. So we'll do what these conventional customs are. Conventional customs are over here. These are also known as usages. So these customs are binding due to an agreement between the parties and not due to any legal authority independently possessed by them. So what do you mean by this? Legal customs are those which are recognized by some kind of authority. Okay? Whereas conventional customs are between two persons. That means two people or two groups of communities or two castes or two religious institutions, whoever, name it. But this conventional custom came about by the agreement between two separate people. Whereas legal customs are those which have the authority of law. That means it's backed by some authority established as the government. Okay, so this is the difference. Now your legal customs are divided into local customs and general customs. So what are your local customs? Local customs are simply a custom which prevails in some definitive locality and constitutes a source of law for that place only. So it will be applicable only to some sects or to some communities. Whereas general customs, okay, are a custom which prevails throughout the entire country and constitutes one of the sources of the law of the land. As simple as that. And now this local custom is further divided into geographical local customs and personal local customs. What's the distinction between this? Geographical local customs are just those customs which are applicable to some particular area, whereas personal local customs are those which are applicable only within that family or only between the relatives in that particular family. So if you have to look at how these customs are divided, the main part is that you must first distinguish between customs having sanction and customs not having sanction. Okay. Now, customs having sanction only is what we're talking about over here. Customs having sanction are divided into legal and conventional customs. What is legal customs? Which has the legal authority of the law. What is conventional customs is any custom which is brought about between two different people. Then you have the local customs and general customs. Local customs are those which are applicable to a particular place, and it is further divided into geographical and personal customs. Whereas your general customs are those customs which are prevalent throughout the entire country. So guys, this customs, the classification is fairly simple. Let's move on to what is the requisite of a valid custom. First one is that it must be immemorial in nature. What do you mean by immemorial? It must be ancient. That is all. They say it here also. It must be ancient. Now, that's all it means. A custom must be so ancient that your grandfather, your great-grandfather and his grandfather before him should probably remember that custom. The second one is that it must be certain. It must be certain and definite. It must not be vague and ambiguous. Means your grandfather may remember the custom, but the grandfather before him remember the custom in a different way. Or the grandfather's brother remembers this custom in a different way. So when there's no certainty amongst the same custom, then it cannot be called a custom. Everybody should know it in the exact same way. The third one is reasonableness. Every custom must be reasonable in society. You can't have unreasonable customs. Means you can't say something like a child as part of that community must bear children at the age of 5 years of age. It is impossible. It is impossible for a 5-year-old girl child to give birth to children. And therefore, this custom is unreasonable. It is almost impossible actually. And therefore, a custom must be first reasonable for it to become a proper custom. And more importantly, if we can say that a custom is unreasonable, if it opposes the principles of equity, justice and good conscience. So, what does this mean? Generally, they'll say that the principles of justice, equity and good conscience equate to the morals of society. So what is not moral in society is basically unreasonable. That's all. Next one is that it must be compulsorily observed. So one group of this community cannot choose not to observe it, and then another group cannot go ahead and decide, okay, we will observe this. No, it doesn't work that way. Everybody should follow it continuously and properly. So the keyword here is continuously and from time immemorial. That means for the longest time possible. It must be in conformity with law and public morality. Means it must not be opposed to morality, or it must not conflict with statute law. That means, what if you have a law which states that there is a custom of stealing? Now, stealing is prohibited by Indian laws. A law specifically says that if you steal, then you will be punishable by law. And therefore, you cannot have a custom which says that it is okay to steal. That means this custom is not in conformity with law and public morality. Next one is unanimity of opinion. Now this unanimity of opinion and compulsory observance can be read together. That means everybody should have a general understanding that yes, this is how you have to follow a custom. It must not be left to individual choice, in the sense that one person cannot follow the custom one way, another person cannot follow custom in another way. Then peaceable enjoyment. Like I said, a custom must be peaceably enjoyed by the people who are following it. It must not cause harm to other people, because if it causes harm to other people, it will not be in conformity with law and public morality. Alright? And finally, consistency. Now, consistency is basically just these customs must be followed properly, just like how it is written in compulsory observance. And therefore, a custom has to have these 8 principles, that is immemorial, certainty, reasonableness, compulsory observance, conformity with law, unanimity of opinion, peaceable enjoyment, and consistency must be there for a custom to be recognized as a valid custom. Now, the fourth and final primary source of Indian law is known as your personal laws. Now, a personal law is also a type of law. That means this is also a statute. So, how then does it differ from statutes and legislation? Because statutes and legislation we studied as the first primary source of Indian law. So, how is this personal law different from that? The answer is that it is not different from each other. Personal laws are also laws which are passed by Parliament, and these are also laws which have the same elements as that of a statute. Rather, personal laws relate to the specific religion or religion of one group of people. Okay. Now, take for example, you have Christians, okay, you have Muslims, and you have Hindus. Now, these 3 different religions follow different practices, whether it's with regards to marriage, whether it's with regards to divorce, or whether it's with regards to inheritance. Each community or each religion follows it differently. Take for example the Muslims, they have the concept of divorce for them, but then the Christians and Hindus do not follow the concept of divorce. Similarly, the manner in which Hindus are married differs completely from Muslims and Christians, and therefore we can say that personal laws are those kind of laws which are applicable in the case of inheritance. In the case of inheritance, inheritance simply means inheriting something from your father. Okay. Succession, marriage, then you have adoption, co-parcenary, and partition of joint family property. What do you mean by this term co-parcenary? It's very simple. You have, let's assume that there is a family property, an ancestral property. Now, this ancestral property was owned by the one person A in the year 1960. Now, over time, A had, let's say, 10 children, and then these 10 children probably had another 10 children, another 5 children, another 6 children, and so on. And now, totally, there are how many people in this entire property? In this end, let's call this the property. This entire property has to be divided into, let's say, 50 pieces of land. Okay, so let's assume this is 50. There are 50 members of this property which have some kind of ownership on this particular property. Now, what this family is also known as is a Hindu undivided family. So we can say that each and every one of these heirs have one share or interest in this property, and therefore each one of these members of this family are known as co-parceners. That's all. So this example of a Hindu undivided family comes under Hindu law. Alright, so that's what, like I said, personal laws will apply in different ways simply because the rules are different. For the Hindus, they're saying that their personal law can be found in Shrutis, which also includes the 4 Vedas, and the Smritis, which are basically a collection which is handed down as ancient teachings by the rishis. Or these are basically certain rules or the way of life which has been coded into certain books, and these books are what you call the smritis. Now, Hindus are governed by the personal law with regards to inheritance, succession, marriage, adoption, co-partnery, etc., or even the pious obligations of sons to pay their father's debt, okay, guardianship, maintenance, and religious and charitable endowments. So with all of these matters, even though there exists a law which is applicable to the entire country uniformly, with regards to Hindus in and under these topics, those specific laws will be applicable. Now with regards to the personal law of the Mohammedans. Mohammedans are basically just who we know as Muslims. Now the Muslims have their source in personal law from different sources. What are these different sources? The first one is the Holy Quran. The Quran is their religious book or religious teachings which is actually a very, very important source of Mohammedan law. After the Holy Quran, you have the actions, precepts and sayings of Prophet Muhammad. So, aside from the Holy Quran, you have the sayings of Prophet Muhammad, which he has said or which he has done as an activity during his lifetime, and these activities or things that he said has been noted down by certain authorized persons known as the Hadis, and these people have preserved this tradition and they've passed down this tradition through the ages of Muslims. Next one is ijmas. Ijmas is basically a concurrence of opinion of the companions of the prophets and his disciples. So in the constant communication that existed between Prophet Muhammad and his disciples, then any kind of opinions which came out of it was recorded as the ijmas. Then you have the qiyas or the reasoning by analogy. So from the Holy Quran, from the Hadith, you have ijmas. From these you have something known as reasoning, analogical deductions. That means reasonings or logical reasonings which have been written down and preserved, and these are known as the qiyas. And finally, digests and commentaries on Mohammedan law. So there'll be many jurists or academicians who've come forward and basically written textbooks on the various various sayings or doings of the Prophet Muhammad and his disciples. The Mohammedans are also governed by their personal law as modified by statute, law and custom with regards to inheritance, wills, succession, legacies, marriage, dowry, divorce, gifts, waqfs, guardianship and preemption. So these are all the things which the Muslims are governed by with regards to their personal laws. Now, you may ask the question, ma'am, I still haven't understood what is the difference between statute and the difference between personal law. Okay, simply put, personal law is applicable to certain groups of people on the basis of their religion. And not just their religion, but more importantly, these topics. Wherever it relates to marriage, dowry, divorce, or guardianship, etc., then at that time the personal law will apply rather than the normal statute which is applicable to the whole of India. Okay, so these are only known as personal laws. Same thing will apply in the case of Hindus, and the same thing will apply even in the case of Christians. So friends, we've completed the primary sources of Indian law, and the first most primary important source is statute or legislation. The second one is judicial precedents. The third one is customs, and the fourth one is personal law. And that's all for this video, guys. Do go ahead and subscribe to my channel, as I will be putting out more and more content on jurisprudence, interpretation and general laws, and do press that bell icon so that you'll get more personalized notifications for the same.